Good morning. Are you Kashawn Purdy? And Ms. Purdy is on probation and cause number 24, DCCR 1272 for the state jail felony offense of unauthorized use of a vehicle. And there's a new indictment in cause number 25, DCCR 1523, charged with injury to a child, elderly, or disabled individual. Mr. Kimler has filed a motion asking for a bond in that unauthorized use case that has the motion in it. Mr. Kimler, you may proceed.
Your Honor, I think she's on deferred. I've reviewed a little bit. I haven't actually gotten discovery on the new case yet, but I have reviewed some photographs that were taken by the defendant's family with injuries. I don't want to downplay it, but it appears to be sort of the minimus type of injury. It's not, and I'll defer to Mr. Hawkpower, may have a different opinion on that. We're simply asking for a bond on the under.
This right here is a classic courtroom chess move. The defense is trying to minimize the injury before the prosecution can define it, because in bond hearings, perception matters almost as much as proof. Court doesn't have to decide guilt today, only risk. And when photos are involved, judges tend to take the cautious route. Drop a comment. Should alleged injuries ever be brushed off this early in a case? Interview 2.
Motion to revoke probation to allow time to prepare to defend the injury to a child case.
I can't, hold on. Y'all, I'm having a hard time. So if you're talking about a case, for some reason, I'm having a hard time. I've got a cold and my ears are stuffy. Y'all need to step in the back. If you're not talking about a case, I need you to really be quiet.
And I'll try to
Speak up, please.
And additionally, she is pregnant. I think that, and I did receive a write-up from that was emailed to me from the jail. And to the best of my understanding, it appears she was wearing, I guess, a blue wristband to indicate that she's pregnant. There was some, I don't know, misunderstanding on the part of the jailer as to whether some other female inmate had given her the wristband. Evidently, they get extra rations or extra portions of food and their vitamins and stuff if they're pregnant. But it appears from the write-up that she actually is pregnant, so I don't know that it was a disciplinary write-up or what the purpose of the write-up is, but she certainly, other than that, hasn't had any problems in the jail, to my knowledge.
All right, you want to put on some evidence with regard to her ability to pay? Would you raise your right hand the best you can? You swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Yes, ma'am. Thank you.
Ms. Purdy, the judge just wants to know your ability to pay a bond, to actually come up with the funds necessary to pay a bond when you get out of jail. What's your financial situation right now? Just generally speaking.
I had got laid off back in September, but I had got another job at the end of October. So I'll be able to pay my bond.
How much do you have available now to pay a bond as far as money that's put aside to pay a bonding fee to get out?
Like 500, 600.
Okay, and then hopefully after that you get your job and would be able to work.
Yes, sir.
Okay.
Yes, sir.
Do you have any savings or checking, money in the bank, anything like that?
No, sir.
Do you own your own residence, your own home? Do you own your own?
Rent, yes, sir.
You rent? Do you own any vehicles?
No, sir.
What about any other thing of value that you might own? Anything?
No, sir.
Okay. That's what
I need to know, how many children do you have?
I have 2 and 1 on the way.
And where do they live, with you?
Yes, ma'am.
So if you make bond, where are you going to be living and with who?
At my home.
Who lives at your home?
Me, my 2 kids, and my fiance.
Did Child Protective Service get involved in this?
Yes, ma'am. They closed the case. And I was also taking anger management and parenting class also.
Through CPS?
Yes, ma'am.
But you didn't finish those because you got incarcerated?
Yes, ma'am.
Okay.
Right.
What's your relationship with Kamari?
It's my oldest. I talk to her every day. She tells me every day, she say, Mama, I'll pray.
I don't care,
Yeah, just answer the questions.
because you're not gonna be allowed to be around them if you make bond. So you gotta figure something else out until I figure out what's going on with your
Yes, ma'am.
case. So that's gonna be, who are they with now?
My mom.
Okay. So if you make a bond, then they're gonna have to remain there. You're not gonna be able to have unsupervised contact with them until further order of the court. Do you understand? That would be a condition of your bond.
I totally understand.
Okay. Mr. Hoffpower, what's the state's position?
Judge, that was our concern.
Bond granted, but at a steep price. $30,000, no unsupervised contact with any children, and mandatory CPS compliance. This is the court walking a tightrope between due process and child protection. Legally, this is huge. She's free only if she agrees to live under strict surveillance. Question for you, is this fair caution, or does it feel like punishment before trial?
Is the new offense, I disagree whether or not it was de minimis or felony court.
Well, and for the record, I am reviewing the probable cause in that case just to get a little bit of information on what the allegations are.
I was talking about a photograph, so.
What else?
Simply judge that she's on felony probation and allegedly commits a felony. We'll leave it to the court's discretion.
All right, so I'm going to grant the motion to set a bond in cause number 24 DCCR 1272. I'm going to set that bond at $30,000. A condition of that bond is that you have no unsupervised contact with any children, including your own. And that you complete whatever CPS is requesting that you do. So if they started classes, you need to continue with those and whatever they request of you. Do you understand?
Yes, ma'am.
All right.
Comply with CPS.
All right, you can go back with the bailiff.
This courtroom hearing centers on Kushin Perry, who is already on felony probation for unauthorized use of a vehicle. Now, she is facing a new and very serious indictment for injury to a child, elderly, or disabled person, which puts her freedom at risk. Her defense attorney asks the judge to set a bond in the older probation case. He argues that the alleged injuries in the new case appear minor based on photos and says the defense has not yet received full discovery. This is a strategic move, trying to minimize the situation early before prosecutors fully present their case. However, in bond hearings, judges focus on risk, not guilt. The defense also tells the court that Perry is pregnant, explaining a jail report involving a pregnancy wristband. The judge then questions Perry directly about her financial situation. She explains she was laid off, recently found a new job, and can only afford $500 to $600 toward a bond. She has no savings, no property, no vehicle, and rents her home. The judge also questions her about her children. Perry has 2 kids, but due to the nature of the charges, the judge makes it clear that if she makes bond, she cannot have unsupervised contact with any children, including her own. Her children will remain with her mother. Child Protective Services is already involved, and Perry admits she started anger management and parenting classes but couldn't finish them because she was jailed. After hearing both sides, the judge grants bond, but under strict conditions. The bond is set at $30,000, with no unsupervised contact with children and mandatory compliance with CPS requirements. This case highlights how courts balance due process and child safety, showing that even before trial, freedom can come with heavy restrictions. The question remains, is this necessary caution or punishment before guilt is proven?